I'm your host Evie, here to guide you through today's fascinating journey into the intersection of AI, copyright law, and global jurisdictional challenges. As artificial intelligence becomes increasingly integral to our daily lives, it also raises complex questions about how traditional legal frameworks can keep pace with rapid technological advancements. Today's episode will explore these complexities, starting with a riveting case involving OpenAI and its widely used AI model, ChatGPT. You might have heard about recent legal proceedings in India, where an intriguing lawsuit pits OpenAI against the Indian news agency ANI. ANI has accused OpenAI of using its content without permission to train ChatGPT, sparking significant debate about copyright infringement in the age of AI. OpenAI, in its defense, argues that deleting the training data used for ChatGPT could violate its legal obligations in the United States, where it is already embroiled in similar lawsuits. This case highlights not only the tangled web of copyright issues AI companies face but also raises critical questions about jurisdiction. How do international legal principles apply when a company without a physical presence in a country is called to account in its courts? This is precisely the sort of challenge that AI innovators and legal systems worldwide are increasingly confronting. Moving away from India, we also turn our attention to the United Kingdom, where the government is proactively seeking to reshape its copyright framework to better address the unique challenges presented by AI. Their proposals include introducing a new text and data mining exception, increasing transparency requirements for AI developers, and possibly requiring AI-generated outputs to be clearly labeled. These potential changes could have profound implications not just for AI developers, but also for creators and consumers alike. Lastly, we'll round off this episode by looking at the United States' stance on AI-generated works, specifically through the lens of the US Copyright Office. Their recent guidance reaffirms the long-standing requirement for human authorship in copyright law, sparking debates on whether this traditional view can accommodate the creative potential that AI now offers. So, whether you're a legal enthusiast, an AI developer, or simply curious about the future of technology and society, settle in for a compelling discussion as we navigate these uncharted waters together. Let's dive into our first case in January 2025, where we'll explore the captivating legal battle between OpenAI and ANI, an Indian news agency. This case has captured international attention, highlighting the complex intersection of AI, copyright laws, and jurisdictional challenges. The dispute began when ANI filed a lawsuit against OpenAI, accusing the tech giant of using its published content without authorization to train ChatGPT. ANI demands that all its data be wiped from OpenAI's repositories. However, OpenAI's response has underscored a significant legal conundrum. They argue that deleting this data would contravene existing legal obligations in the United States, where they are mandated to preserve all training data amidst ongoing legal proceedings. This case is interesting not only for its copyright implications but also for the jurisdictional questions it raises. OpenAI asserts that Indian courts lack authority in this matter, emphasizing the company's absence of a physical presence or operations within India. This brings us to the challenging question. In a world where digital services transcend borders, how do we determine applicable legal jurisdictions? Understanding jurisdiction in the digital age involves grappling with how laws apply to entities operating globally without a local footprint. This issue is crucial for multinational tech companies who must navigate a patchwork of national regulations while maintaining compliance across various jurisdictions. It also begs the question of whether existing legal structures are equipped to handle the digital and virtual realities AI technologies present. Meanwhile, ANI argues that Chennai's High Court does possess authority, given the widespread use of OpenAI's products in India and the impact of ChatGPT's outputs derived from ANI's content. This evolving case between ANI and OpenAI could set a precedent for how countries handle disputes involving international AI companies. It highlights the need for legal frameworks to adapt to the digital age, ensuring they can adequately address transnational technology issues. What might the resolution of this case mean for AI innovation and international copyright laws? Only time will tell. As we shift our focus from India to the United Kingdom, we find ourselves amid a proactive approach to redefine copyright in the age of AI. The UK government recently launched a consultation proposing significant reforms to its copyright framework, aiming to accommodate the rapidly evolving AI sector. These proposals are driven by three primary objectives: empowering rights holders to control their content, encouraging the development of leading AI models within the UK, and fostering trust between creators and AI developers through greater transparency. One of the standout elements of the proposal is the introduction of a new text and data mining (TDM) exception. This exception aims to allow AI developers to mine data for any purpose, provided they have lawful access and rights holders have not expressly reserved their rights. This move could pave the way for new AI breakthroughs by making more data accessible for training models. However, this also raises questions. Could the TDM exception potentially clash with the rights of content creators? Balancing innovation with the protection of intellectual property is a complex dance, where transparency becomes a crucial piece. To this end, the UK government suggests new transparency obligations for AI developers, ensuring that any use of copyrighted material is clearly documented and communicated. This aligns with international efforts such as the EU's AI Act, promoting cross-border regulatory coherence. Furthermore, the proposed changes also address AI-generated content labeling, potentially requiring outputs to be designated as AI-created. This reflects broader concerns about authenticity and originality in an age where AI can generate remarkably human-like content. The UK's proactive stance might inspire or provoke similar initiatives elsewhere, as countries seek to align their laws with the realities of AI. How these changes take shape and their eventual impacts on both the AI industry and copyright regime remain critical questions. Next, we cross the Atlantic to the United States, where the Copyright Office has carved out a distinctive approach to AI-generated works. At the heart of this discussion is the age-old human authorship requirement, long enshrined in US copyright law. Historically, the US has held firm that some level of human creativity is necessary for copyright protection. This principle faced fresh scrutiny in cases like the recent entrance to Paradise and Zaire of the Dawn, where the US Copyright Office grappled with AI's role in content creation. In the case of the recent entrance to Paradise, the work's AI-generated origin was pivotal to its denied copyright registration, signifying a lack of the essential human element. Similarly, the graphic novel Zaire of the Dawn, although initially granted copyright, saw its AI-generated images excluded once their origin was revealed. The Copyright Office's 2023 guidance builds on this, reaffirming that human authorship is a prerequisite for copyrightability. It does, however, leave room for works created with significant human involvement, where the human element exercises creative control over AI-generated content. These decisions underline the challenges of fitting AI advancements within existing legal paradigms. When does AI become more than just a tool, and does that shift redefine authorship? These questions are central to ongoing legal and philosophical debates. The implications of these rulings extend beyond the US, signaling a need for countries worldwide to reconsider how they incorporate AI into their copyright laws. As AI continues to evolve, ensuring that laws balance innovation with intellectual property protection is crucial. The implications of these rulings extend beyond the US, signaling a need for countries worldwide to reconsider how they incorporate AI into their copyright laws. As AI continues to evolve, ensuring that laws balance innovation with intellectual property protection is crucial. As we delve deeper into this final case, it's abundantly evident that the discourse surrounding artificial intelligence, copyright, and jurisdiction is not only multifaceted but inherently global. Each country's approach, be it India, the UK, or the United States, provides a unique perspective on how to navigate these contemporary challenges, reflecting the cultural, legal, and economic priorities. In today's interconnected world, the rise of AI has transcended geographic boundaries, demanding responses that are both innovative and respectful of diverse legal traditions. This has led to an intriguing tapestry of strategies. On one hand, countries like the UK are actively reshaping their legal frameworks to better accommodate AI's potential. They're rolling out comprehensive consultations focused on updating copyright laws to meet the needs of the digital age. Key proposals like the text and data mining exception signify a paradigm shift, one that may serve as a template for others. On the other hand, the United States has chosen a path deeply rooted in its long-standing legal precedents. The upholding of the human authorship requirement by the US Copyright Office insists that copyright protection should continue to hinge on human creativity. This approach reflects a cautious balance, embracing innovation while safeguarding the principles that underpin intellectual property laws. Meanwhile, in India, the courtroom battle involving OpenAI and ANI underscores a different facet of this global conversation. Here, the focus is on jurisdictional authority and the protection of local content in a rapidly digitalizing world. India's case exemplifies the challenges faced by nations attempting to enforce domestic laws on global entities whose operations transcend borders. These varied approaches beg important questions. Should there be a unified global standard for AI-related copyright issues? After all, the nature of AI is such that its implications and applications invariably transcend national borders. The development of international treaties or collaborative frameworks might emerge as viable solutions, striving for consistency in how AI and copyright are managed globally. However, such an endeavor is not without its challenges. While a global standard could theoretically harmonize regulations and provide clarity, it would require unprecedented international cooperation. Countries would need to reconcile differing legal traditions, priorities, and cultural values. Moreover, the pace of AI advancement further complicates such cooperation, often outstripping the speed at which legal frameworks can adapt. The alternative is a continued reliance on national regulations, but this could lead to a fragmented legal landscape where multinational AI enterprises face differing rules in every jurisdiction they operate within. This patchwork approach might stifle innovation, as companies navigate a labyrinth of local restrictions and obligations. Therefore, the path forward must delicately balance several key considerations. It should aim to unlock AI's vast potential without being hampered by antiquated legal systems that fail to accommodate new technological realities. Simultaneously, it must safeguard the rights of creators, ensuring that their intellectual property is respected and adequately protected. The stories and cases we've discussed highlight this tension, illustrating the need to reassess and potentially redefine legal concepts that have long been taken for granted. In light of these global developments, keeping a vigilant watch on how these cases and reforms develop is more than just prudent, it's essential. Their outcomes will not only determine AI's legal status but could also shape the larger technological landscape for decades. They have the potential to influence innovation trajectories, impact economic paradigms, and redefine the boundaries of intellectual property. As we wrap up today's episode, let's remember that the intersection of AI and law isn't simply about technology or regulation. It's a deeper reflection of how these issues are woven into the very fabric of our modern society. It's about understanding how AI doesn't merely represent a new tool or innovation but challenges us to revisit and possibly redefine fundamental legal principles. It's a compelling reminder that, as society progresses, so too must our frameworks of understanding and regulation. Thank you for accompanying me on this journey through AI's intricate legal conundrums. I genuinely hope that today's discussion has enlightened and inspired you to think critically about the evolving relationship between AI and law. Remember, as the technological landscape continues to shift, it's crucial to remain informed and engaged with these pivotal conversations. They are not just about navigating present challenges but preparing for future opportunities. As we continue to explore the dynamic world of technology, be sure to join me next time for more insights and discussions. The landscape is ever-changing, and there is always something new to uncover. Until then, keep questioning, stay curious, and always look beyond the headlines to understand the deeper implications of the digital age. If you enjoyed today's discussion and found it valuable, please subscribe to the podcast, leave a review, and share it with your community. Until next time, stay curious and keep innovating. I'm EV, and this is AI Forever, establishing smart living.